Salam everybody. This is our discussion video about relationship of partner and third parties, liabilities of partner, appointment and retirement of partners. These are the members of our group. First of all, my name is Muhammad Habib Febrian, and then we have Faki Al-Rashid Desta Soekarno, Gatan Ibrahim, Hanif Mutawali, Taufik Nur Arifin, and Tiara Nur Afifa Salsabila. And the first topic will be discussed with me. I will explain about relationship between partners and third parties. In Section 7 of Partnership Act 1961, stated all acts done by a partner by another. The condition of this action, which bind the other partners, have to be fulfilled by three acts. First, the act of a partner must be done for the purpose of the business of the partnership. An act by one partner can bind the other partner if the act is done for the purpose of the business of the partnership or in relation to the partnership business. Case: Chan King Yu v. Lee and Wong. The plaintiff's husband borrowed from her $3,500 as a loan to the partnership in which he was a partner. He gave her a receipt in the name of partnership. The money was paid into the partnership to pay off its debt. The plaintiff initiated an action to recover the loan against the firm. The other partner of the firm denied liability by contending that the plaintiff's husband was not authorized by the firm to borrow the money. Held, since the loan was in fact utilized to pay off partnership's debt for the purpose of business, all the other partners are also liable for repayment even though the borrowing was made by a partner without authority. Okay, next part will be explained by topic.
The act of a partner must be done in the ordinary course of business of the partnership. The term ordinary course business means that the act must be necessary, connected, relevant, and reasonably normal for the business of the firm to be carried on. Case: Mercantile Credit Company versus Garrett. Parkin and Garrett were partners in the business of letting low-cost garage and repairing cars. Garrett was a sleeping partner. The partnership agreement between them excluded the buying and selling of cars. Parkin sold to Mercantile Credit a car to which he has no title. Mercantile Credit sued Garrett as a partner to Parkin and demanded his money back. Hell, Garrett as a partner is liable for the act of Parkin, his partner, because the third party, Mercantile Credit, didn't know Garrett has no authority to sell the car. Next, the act of a partner must be done by a partner as a partner of the partnership. If the partner enters into the transaction in the partnership name, that certainly can be considered as acting as a partner of the partnership, and he has the power to bind the firm accordingly. Case: Rubrix and Company X partner right. A father and son were partners in the firm of Rubrix and Co. The creditor put in claim against the firm, but there was no money to meet the claim. In consideration of the creditor giving time to pay, the son agreed that an assessment of the book debts to the creditor shall be made. The agreement was made by the son without the father knowledge. The contract of assessment was made under the name of Rubrix and Company. Hell, the contract of assignment bind the firm because the son executed it as a partner of the firm when he made it in the name of Rubrix and Company.
So the next topic is the liability of partners. The first one is contractual. Section 11 of Partnership Act 1961 stated that every partner in a firm is liable jointly with the other partners for all debts and obligations of the firm incurred while he is a partner. And after his death, his estate is also severally liable in a due course administration for such debts and obligations. What is pointed out in this section is the difference in a partner's liability. This section mentions two types of liability. The first one is a joint liability. So every partner is liable jointly with the other partners for all debts and obligations of the firm incurred while he is a partner. It means that each and every one of the partners is liable for the whole debt of the partnership. And then the second one is the several liability. When a partner dies, he will still liable for the debts and obligation that arose while he was a partner. Liability is imposed on his estate depending on whatever funds remain after the executors of his estate have settled his separate personal debts.
Tortious, Section 12 of Partnership Act 1961 stated that where, by any wrongful act or omission of any partner acting in the ordinary course of the business of the firm or with the authority of his CO partner, loss or injury is caused to any person not being a partner in the firm, or any penalty is incurred, the firm is liable thereafter to the same extent as the partner so acting or omitting to act. There are two conditions that have to be satisfied before a partner can bind the firm for wrongful act committed by him. First, the wrongful act must be committed in the ordinary course of business of the firm. The firm is liable for the wrongful act or omission of a partner in a way similar to the various liability principle, where a principal is liable for torts committed by the agent which are authorized or ratified by the principal. Second, the wrongful act must be committed with the authority or consent given by the other partner. If it's not in the ordinary course of business, the wrongful act must be committed while carrying on the job with the authority of CO partner. Criminal liability is personal liability of partner who has committed to it. In other words, the other partners are not liable for the crime committed by a partnership.
And now we're going to talk about holding out. So, what is holding out? Based on the Section 16 of Partnership Act 1961, stated that everyone who by words, spoken or written by conduct represents himself, or who knowingly suffers himself to be represented as a partner in a particular firm, is liable as partner to anyone who has on the faith of any such representation given credit to their firm, whether the representation has or has not been made or communicated to the person, so giving the credit by or with the knowledge of the apparent partner making the representations or suffering it to be made. The term holding out simply means where a person is not a partner make it known either by his words or conduct to a third party that he is a partner. Due to the representations, he would be liable as if he was partner. The estoppel doctrine is the basis of liability for holding out, where a person make a representation to a third party and that third party believing the representation acts on it. The person make the representation will be estopped from denying that the statement had been made. Three basic principles for liability of a person holding out are: first, there is representation, where a person consents or knows that his name is used as partner or where he holds himself out to be a partner. It can be expressed or implied or made orally before credit is given. Second, there is reliance on representation by the third party. The statement of conduct of holding out is communicated to the third party, who then acts on the statement. The third party must show that he was aware for the holding out. He must show that he had given credit to the firm because he had relied on the representation. The third, as a consequence, credit is given to the firm. The doctrine of holding out applies in favor of persons who have dealt with the firm of the faith that the person whom they seek to make liable is a member of it. It is not applicable in this case of tort or crime to enable the person to escape liability out of his true position.
Appointment of partner. Section 19, Clause 1 of Partnership Act 1961 stated that a person who is invited as a partner into a exercise firm does not become liable to the creditor of the firm for anything done before he became a partner. An incoming or new partner who has just been admitted into a firm is not liable for debts incurred prior to his admission. He is only liable for the debts incurred by the firm after his admission. All the partners must agree with the appointment of new partner. Retirement of partner. Section 19, Clause 2 of Partnership Act 1961 stated that a partner who retires from a firm does not cease to be liable for partnership debts or obligation incurred before his retirement. An outgoing or retiring partner remains liable for partnership debts or liability incurred while he is a partner regardless his retirement. A partner cannot avoid liabilities by resignation or retirement. Section 19, Clause 3 of Partnership Act 1961 stated that retiring partner may be discharged from any existing liability by an agreement to that effect between himself and the members of the firm as newly constituted and the creditor. And this agreement may be either expressed or inferred as a fact from the course of dealing between the creditor and the firm as newly constituted. Okay, I think that's all from our material. Thank you for watching.